So next up, we have Toby Crooks, partner in the Trust and Wealth Services Department at Rawlinson and Hunter, and Toby is going to talk to us about pre-arrival planning for high net worth UK res non-doms.
So I thought that before I go on and speak specifically about pre-arrival planning, it might make sense just to sort of take stock of where we are at the moment. So, I mean, the good news, obviously, is that the threat of the abolition of the res non-dom rules has lifted for the time being. But certainly what we're seeing is a further erosion of the advantages, and I think if we're realistic about things, I think that probably that's a trend that's only going to continue. In terms of the known changes, what has happened recently and what might happen in the future, with effect from the current tax year, we've obviously got the higher charge being introduced for long-term residents who have been here for 17 out of the previous 20 tax years, so the 90,000 charge. We've also got an increase in what will become the mid-tier charge for those individuals who have been resident in 12 of the previous 14 tax years to 60,000. And we've also got, we've had consultation on the possibility of a minimum period of lock-in for taxpayers, long-term residents claiming the remittance basis of taxation. I mean, one of the suggestions is that there may be, for example, a 3-year lock-in. So, I mean, if one thinks about the implications of that for a very long-term resident in the UK, they may be looking at a minimum charge to access the remittance basis of £270,000 if there were to be a 3-year lock-in period. That's a proposal that's under consultation. We haven't had the responses to the consultation process yet. It's possible that we may receive those at the time of July's budget. Just in terms of what we can perhaps expect from the Conservatives, just to note that in their manifesto, specific reference was made to the increasing of annual charges, and also tackling abuses of the status, and it's not really it's not clear what they were getting at there, but I mean, certainly if you look at the rhetoric that's been around sort of recently, I mean, perhaps in July it's possible that one might see a restriction of the concept of domicile for tax purposes, because of course domicile is a legal concept that exists beyond tax, but one possibility perhaps is that individuals who are born in the UK, it may be that in the future they're not able to claim to access the remittance basis of taxation, and I mean possibly sort of extending that. I mean, might it be that in the future, if you're a UK citizen, might that be an impediment to your ability to access the remittance rules? And then just a final point on this before I go on to the pre-arrival planning, the possibility that the charge for long-term residents you have to pay to access the remittance basis of taxation, at the moment that kicks in year 8. Once an individual's been resident in the UK for 7 years, and the starting charge at the moment is £30,000. But could they bring that down to 5 years, or even fewer years? And that might be, I think, where the trend goes. And what does that mean for individuals who are not only going down the Tier 1 investor route, but coupled with that, establishing sort of tax residence in the UK as well? Might it be that some of those individuals who otherwise would have contemplated coming to the UK, might they go elsewhere? We shall see. So just in terms of sort of pre-arrival planning and sort of generic points that one should sort of bear in mind as part of the process of moving to the UK. I don't want to sort of teach anybody here to suck eggs. And I'm sure that a lot of these points will be sort of familiar to you all, but just to sort of flag some of the key points. There's obviously, before an individual becomes tax resident in the UK, there's a one-off opportunity really to consolidate funds which in the future can be clean capital and can be remitted to the UK as things stand at the moment without any tax charge whatsoever or even any reporting requirement in the individual's tax returns. So certainly the discipline of establishing a capital account is a good idea and a sensible one. So to understand what it is that your client has in terms of their existing sort of bank account structures and arrangements needs to be understood. Also, to the extent that the client is able to control the receipt of income from businesses that they may be involved in and subject to local tax considerations. If there's an opportunity, say, to take a dividend from a company pre-arrival as opposed to sort of post-arrival, then that is clearly sort of tax advantageous. Also, looking in detail at any sort of share awards options that your clients may have, could there be a case to exercise those prior to commencement of UK tax residence? Of course, there's always going to be a non-tax element to these decisions, but certainly sort of looking at any opportunities there from a tax perspective is sensible planning. James is going to discuss in a bit more detail sort of optimum bank account structures for UK res non-dom individuals. Just to say briefly on credit card arrangements, that's a common area where people slip up, and the classic example would be where an individual has a credit card which they're using for various UK purchases, and it's being settled from an account containing foreign income and gains, and that may be a sort of pre-existing arrangement, and of course it doesn't sort of cause any issues whilst they're non-resident, but you have a remittance, a taxable remittance issue that will immediately arise once they become resident. So understanding how the client is going to fund themselves on a day-to-day basis in the UK tax efficiently is important. Reviewing the investment portfolio generally should be part of the pre-arrival planning. Of course, the advantage of the remittance basis is that foreign income and gains, any UK tax on those can be deferred potentially indefinitely to the extent that that there are no remittances to the UK. So to the extent that their existing portfolio is held directly by the clients and they're invested in investments that would throw off UK income or UK gains, then subject to continuing to sort of meet the overall investment objectives, should consideration be given to disposing of those investments or restricting the investment mandate going forward? Quite possibly so, I'd suggest. Also, is there, can adjustments be made to the portfolio so that more tax efficient investments are held from a UK perspective? So in relation to offshore funds, many of you will be aware that from a UK perspective, if they are so-called non-reporting funds, if they don't have a particular designation with the UK tax authorities, any profit on the disposal of those investments will be a so-called offshore income gain, which will be taxed at income tax rates subject to remittance. Obviously, as an alternative, could similar investment performance, could the investment objectives be met by investing in reporting funds? These funds, any profit realised will be subject to capital gains tax rates. Again, these are issues to work through in conjunction with the investment managers, and I'd certainly, not be advocating that the investment programme is wholly driven by tax, but tax is certainly a factor. finally here, is there scope pre-arrival to, and again subject to local tax considerations, so wherever the incoming client is tax resident prior to their immigration to the UK, is there scope to realise some of the investments which are standing at high pregnant gains, with the view then to, on subsequent sale of those investments, assuming those investments aren't reacquired, then you've essentially sort of capitalised that profit, and the proceeds could be remitted to the UK subject to proper segregation when the client becomes UK resident. Equally, an alternative there, subject to the bed and breakfasting rules, and if the client's willing to accept the market risk, is to dispose and then, after a period of time, to reacquire those investment positions. If there were then to be subsequent sales when the client is resident in the UK, then there will only be the incremental gain on top of that. And so, again, if there were to be a remittance of those proceeds subject to appropriate segregation, it would be quite a cheap way of bringing funds into the UK. So various issues to sort of think about on the investment side. Reviewing existing life assurance arrangements is pretty important, actually. Obviously, sort of insurance, insurance and life policies generally are widely used by our international clients. The example I've put there is the sort of Assurance V for French clients, which is equivalent really to the bog standard ISA savings product in the UK, but critically it involves a life cover element, and unfortunately in the vast majority of circumstances the policy is written such that it will be caught by these personal portfolio bond anti-avoidance provisions, and this is a really critical point because there's no remittance basis for life insurance policies generally, so that's point one. But point two, if policies are caught by these particular anti-avoidance provisions, then there's a punitive 15% charge per annum which compounds, irrespective of the performance of the investments within the life policy. And in general terms, if the policy permits a degree of control and self-selection by the policyholder, then you have an issue. And it's vitally important to identify where this may be an issue on clients coming to the UK, because you have limited time really to address the issue before the 15% charge becomes extremely punitive. But if you can surrender the policy, collapse the structure within the tax year of arrival, then you can avoid the first 15% charge. And also just to note more generally that having said that there's no remittance basis on the surrender of life policies which aren't caught by the personal portfolio bond provisions, having said that, to the extent that that policy's been held for a period of time before the client comes to the UK, then there's a time apportionment of the income gain that arises on surrender of the policies. But just to say, I mean, in relation to life policies generally, they can, I think, be a useful component in wealth planning for UK resident non-domiciled individuals. I won't go into the detail of that, but I think there's a place for them. Reviewing any existing sort of loan arrangements that your clients may have before they come to the UK is important. Many of you will be sort of aware of the changes in the UK Tax Authority's interpretation of the remittance of the issues surrounding remittance of collateral. These were the announcements made in August 2014. So essentially, if a client has borrowed monies which have been brought to the UK, then on the face of it you have a relevant debt, and you now have the possibility of two separate tax points. You have a tax point when that collateral is deemed to be used in the UK, and also on payment of any finance cost associated with that borrowing, and or payment of the principal as well. So you've got to make sure that you sort of understand, particularly where a client's been making use of Lombard loans. They've got a floating charge perhaps over their portfolios. Obviously, at the point that they arrive in the UK, one can be happy that that portfolio is comprised entirely of pre-arrival capital, but then over time, during the period of UK residence, there'll be income and gains generated by that portfolio. To the extent that the loan arrangements remain as they are, then there's certainly the possibility that there could be a derived remittance issue there, because part of the collateral is deemed to be used in the UK in relation to the borrowings that have been brought to the UK. So that needs a careful review. A general review of any offshore trust structures is important, particularly where prior to the arrival of the client in the UK, there have been capital payments made to the UK, and where those capital payments perhaps are unmatched for UK tax purposes. In the absence of any planning, the client comes to the UK, becomes tax resident here, income and gains arise within the trust structure and are then immediately attributed to these capital payments, which may well have been made to the UK before the client was even resident. So there's an opportunity, a tax planning opportunity, to crystallise gains within structures to frank and effectively deactivate those unmatched capital payments. That's a possibility that should be explored. Stockpile where there are existing structures that have within them a lot of income and stockpile gains for UK tax purposes, is there an opportunity in the year prior to arrival to collapse those structures, essentially capitalise in the hands of the individual those stockpile gains and income? It's a way potentially of uplifting and generating more capital for the use of the client when they come to the UK. Sort of whizzing through this then, if you are doing any sort of restructuring involving offshore trust structures and or existing corporate structures, something you always have to be sensitive to is that if structures are left as they are, it's quite possible they will benefit from a so-called motive defence under certain UK sort of anti-avoidance legislation that otherwise would look through structures when a client comes to the UK and attribute income to them immediately, subject to the remittance basis. It just needs to. Often it's the case that the advantages of restructuring have to be weighed against the potential loss of this motive defence, and one has to, if you are restructuring trust structures and corporate arrangements generally, you have to be very careful around the split year treatment for the purposes of the statutory residence test, because it doesn't apply in all circumstances. So certainly the advice in most instances would be, well, make sure that you do this in the tax year prior to your arrival. Don't do it in the non-UK resident part of your tax year of arrival. The bottom point here, looking at sort of business tax risks and opportunities, this is a point particularly, I think, where our client is the entrepreneur, the principal behind the business, remains integrally sort of involved in the day-to-day management, strategic direction of these businesses. One needs to consider what impact that has on the residents of the corporate group when when the client establishes UK tax residence? Is there going to be a sort of central management and control issue that makes the structures UK resident for corporation tax purposes? And here you're looking at obviously how the companies are run at board level, but also really drilling into the day-to-day operations of these companies. I think in the context of some of our clients who might be sort of coming to the UK on investor visas, it may be that in the sort of environment that they come from, it's quite normal perhaps to have a BVI or Panamanian company with nominee directors who essentially act on the instruction of the principals. It may even be that the principal has signatory rights over the company's bank account. That arrangement simply is not going to work if those clients establish UK tax residence from a tax perspective. So it's vitally important to give any structures a health check generally. The applicability of temporary non-residence rules also needs to be considered. So if you're intercepting a client who's thinking of establishing UK tax residence, it's important to understand if they've been resident previously, and if so, on assumption of their UK tax residence, is there a possibility that any clawback charges might arise? And again, I mean, there's an interplay here with claims for the remittance basis. I won't go into the detail of that, but it's just generally a point to be aware of. A further point is there going to be an opportunity for your client to make use of overseas work relief? Do they have an employment that requires them to perform work overseas? Despite the fact of their UK tax residence, are they going to be spending a significant amount of time overseas on their employment? If so, overseas workday relief can be extremely valuable relief. Can be available to the client for the first 3 tax years of residence, just for non-domiciled individuals. This is. There are particular considerations for individuals claiming the overseas workday relief in terms of how their bank accounts are operated. And also, this is not a sort of once-only relief, so that there would be nothing to prohibit an individual from establishing UK tax residence for 3 years, claiming this relief, subsequently becoming non-resident again, provided they have a period of non-residence of 3 consecutive tax years. They can then return to the UK and claim this relief again. And in practice, I've had clients who will do this, who have sort of peripatetic working lives that sort of take them across the world. And then finally, obviously a sort of consideration for many of our clients moving to the UK will be sort of home ownership. What are the kind of issues that we need to look at here? I think that as a general rule of thumb, for the family home, sort of personal ownership really I think is the most straightforward approach to take, and as a consequence of the decreasing attractiveness, essentially, of sort of trust company structures over recent years. But then that brings with it inheritance tax exposure issues in the UK. So consider how can that be mitigated? Is there a possibility of loans from non-resident family members and structures? So the point on home ownership is that it's essentially often a trade-off between securing the inheritance tax protection that one might achieve through ownership via a non-resident company, with the dry tax charges that that kind of ownership arrangement now carries, so exposure to the annual tax on envelope dwellings, any sort of charges on deemed occupation of the property, depending on the precise arrangements. But for investment properties, that client UK investment properties that UK resident non-domiciled individuals may be acquiring, there's still sort of probably compelling arguments sort of in favour of corporate ownership. So that's a little bit of a whistle-stop tour, but hopefully that gives you a sort of indication of sort of some of the factors to bear in mind. Thank you.